First, I apologize a little bit for being less than fully professionally dressed, but I'm going to take the train at 1:22 with my traveling compartment. We met on the train coming, and we're going to meet on the train going back. So we're going to cut out fast after we cut to the front of the lunch line. And so I apologize if it doesn't. By the way, if it doesn't meet your standards, just remember the sign in the Red Dog Saloon in Juneau, Alaska. They have this huge sign on the wall. We hope that our food and service have met your standards. If not, please lower your standards. All right, so are there any first-timers here that, for the first time of coming? 1, 2, anyone else? 3? Oh, 4. Oh, here's a present for you. Walter, I'll give you your present in a second. But have you all seen the Taxpayer Advocate Roadmap? It's really kind of interesting, and one that you probably should order. You can just order it online, and it shows this is worse than a New York City subway system, but it'll justify you charging your high fees because you have to navigate this system. And somewhere in there is the Liens station. You can fold that for me. Okay, thank you. All righty. This is not in your text, but I want to introduce this. You know, when a taxpayer files their tax return, they self-assess, and an assessment is created. Or the IRS can make an assessment based on other rules, all right? So once the assessment is on board, most taxpayers pay, on their thing. Oh, by the way, one other announcement I forgot, and I see you're right here. I forgot, I don't know if Krish was here yesterday, but I wanted to congratulate Krish. He passed the tax court exam this year, and he is now a USTCP, so let's give him a round of applause. I meant to say it, and I almost forgot it. Good job. So now there's an assessment made on the books. What does the IRS have the authority, or do they have the authority to collect the tax? And the answer is absolutely yes. In the Internal Revenue Code is Code Section 6301. This is not in your handout if you want to jot it down. And it is probably the shortest section in the entire Internal Revenue Code. Oh, certainly if it's not the shortest, it's right up there with them. And it says, the Secretary shall collect the tax imposed by the Internal Revenue laws. All right? The Secretary of Treasury, of course, the Secretary shall collect the tax. All right? Didn't say may, said shall. All right? So how do they collect tax? So most of the time they issue you some friendly letters, some one of those computer paragraphs that are there. But if it gets hairy, they are able to do what is called enforced collection. And the enforced collection generally consists of 2 tools. One is the federal tax lien, and one is the ability to enforce a levy and take. Don Gilbert, as some of you met, was the first time here that was a former revenue officer. And I'm sure in Don's career he never seized anything. All right? Did you, Don? Did you seize? Did you seize things when you were RO? He's shaking his head. He doesn't want to admit it. But, guys, in the old days, guys like Don would use a trick. You couldn't seize, for example, a taxpayer's car if it was on his driveway. So what they would do is they would call up and say, Mr. Benoit, would you please, Benoit, excuse me, either way. Mr. Benoit, would you please come down here? We got a question we got to ask you. So Phil would get in his car off his driveway, drive down to the office, And the IRS would be waiting. He'd go in. By the time he came back, his car would be gone because they could seize it on, in public property. But they don't do kind of that stuff anymore. And I think levies, seizures, they're the same thing, are down. Part of it because of the Restructuring Act of '98 and political pressure and everything. But the federal tax lien does enjoy its great existence. Yes? Oh, yeah. It was much different. And that's why RRA 98 really changed the atmosphere. At that time, they actually did it. Even when we started NTPI a long time ago, the seizures were much more prevalent. Okay, so let's take a look. As you note, I think PowerPoint is one of the worst inventions ever created by mankind. All right, so we're not going to use any PowerPoint. You have this handout. If you didn't print it out, you can use it in, you can look on your iPad or just listen if you didn't do either one. The IRM, the Internal Revenue Manual, you all familiar with the IRM? All right. Part 5 of the IRM is called the collecting process. And the IRM has 2 parts where you can find information on liens. I have them for you down about 2/3 of the way of the page. One is in 5.17, and it's called federal tax lien, 512, it's called federal tax liens. And the other one is a subset of 5.17, which is the legal reference guide for revenue officers. And in there are multiple subsections dealing with different topics that a revenue officer, very powerful people, they can do a lot of things, all right? And in portion 517.2, it deals with federal tax liens. So if you ever have any question down the road, those are the 2 places where you should take a look, all right? So let's just look on the top what 5.12 says. It says the Internal Revenue Code provides the IRS a powerful tool allowing the government to protect the public's interest in collecting the proper amount of tax revenues. Remember what 6301 says, your job to collect, all right? And the tool is the federal tax lien, and the federal tax lien is sometimes called the statutory lien. It's created by statute, all right? It's created in the code section 6321. And what happens, why is it important? Because it attaches to everything. All to rights of property and rights to property now and in the future. You owe money, the lien, if it's imposed, is going to be really, really a powerful thing, all right? How does a lien arise? 3 things have to happen. You have to have an assessment, all right? So the taxpayer can make a self-assessment or whatever. Have to have an assessment. There has to be a notice of demand. Hey, you owe us money. Send it in. And then the third thing is the taxpayer either refuses or fails to collect, to give you the money, all right? Once that happens, the lien exists. And to understand that not only does the lien exist, and it may take a little bit of time, but the lien exists back to the date of assessment, all right? If you look there in code section 6322, which is about 4/5 of the way down, it says, the lien imposed by section 6321 shall arise at the time the assessment is made and shall continue until the liability for the amount so assessed is satisfied, meaning the taxpayer pays up, or becomes unenforceable by reason of lapse of time. We'll go over what that means in a couple of minutes, all right? And you'll notice in the middle of the page, I love to quote tax cases because They, most of the time, are well written, and they have language that really makes, to me, an impression. And this is a case from the Supreme Court in National Bank of Commerce. The statutory language, all property and rights to property, appearing in Section 6321, is broad and reveals on its face that Congress meant to reach every interest in property that a taxpayer might have. Stronger language could hardly have been selected to reveal a purpose to assure the collection of taxes. All right? Remember, at 6301, you must collect the tax. All right? So it's the lien is really a powerful tool. And as I said, one of the things that you need to do is make the notice and demand. And the thing on the bottom of the page reemphasizes that even though the notice of demand and for payment and the taxpayer's failure may take a little bit of time, the lien goes back to the date of assessment. All right? And on the top of page 3 in the handout, there is a quote from a case called Iannone, which emphasizes that again. We don't need to read that. But in the box, there is really an important idea there that a lot of people don't understand. When you go to bankruptcy, if a taxpayer goes to bankruptcy, their debts are discharged, but only on a personal level. They're no longer personally responsible, perhaps. But what about the lien? Does the lien go away? No, the lien, which is attached to property at the time of bankruptcy, stays there. So you don't get a freebie, all right? The only way a lien can be released is if we'll talk about it, the 10-year period for collection goes, or it is the taxpayer pays the money, all right? So understand that bankruptcy is not the end of the road for taxpayers that owe money. If there is a lien in place on property or rights to property, it will continue, all right? And if you look at the box, you see the two differences. This action, they use the Latin phrase, is a debtor in rem, all right? That part gets discharged, but not the other part, all right, where it still continues. All right, on page 3 is the duration of the lien. I use the phrase unenforceable by passage of time. What does that mean? Well, it means the IRS, while they're charged to collect tax, there is a limitation on the period of time. This is not a forever and ever, all right? Code section 6502 prescribes the period of time for which the IRS has the right to collect the tax, all right? It used to be 6 years. When President Clinton was in office, they changed it to 10 years. So as a general rule, if you ever look at the Internal Revenue Code, almost every section, has the phrase, in general, generally, the general rule. Because what did Judge Learned Hand always say? There's always what? An exception, all right? And there's always an exception. So, therefore, you always have to keep in mind that while the statute says that the 10-year period is the period for collection, all right, understand that there are other factors that might extend that 10 years. And as an old age, you better be careful that you understand that, and you don't say to somebody, how long ago was the tax? Oh, 10 years ago, 11 years ago. Oh, don't worry, 10 years went by. Doesn't always happen that way, right? Doesn't always happen. So you have to be really careful about what you say to somebody. And remember, just one other thing about collection. If you look at Code Section 6502, where the statute is for collection, It reads collection after assessment. You cannot have collection until an assessment has been made. And as an enrolled agent, some folks say, I don't want to do any collection work. Well, then don't do it. Make sure that there are no assessments. Make sure, seriously, if there's no assessment, if you can solve the problem before it gets to an assessment, obviously sometimes you can't do that. If you have a taxpayer that owes $5,000 and you file the tax return, you can't do that. You can't stop that assessment. But if you have an audit or something, make sure you try. And always remember, there can't be collection unless there is an assessment. All right, well, Dawn, I'm going to get to that later. Dawn's talking about there's a problem with releasing the liens. Actually, the liens now self-release. I'll talk to you about that, but wait a little bit longer in the from a legal standpoint and from a practical standpoint, maybe two different things, but we'll get to that in a little while. All right, on page 3, I gave you some of the factors that might increase the 10-year statute. If you look there are the first 4, the taxpayer is outside the United States. It's not just if you're outside the United States. You have to have been there for a period which the taxpayer is out of the United States for a continuous period of at least 6 months. So let's suppose you're on job assignment and you're on a 9-month assignment in the United Kingdom. You work for a big bank or something, all right? They can't collect that during that time you're away. That period gets added on to the 10 years, all right? If you file a bankruptcy petition, all right, you know when bankruptcy is a petition is filed, what happens to collection? It stops, all right? So it is, how long does it stop? It stops for the period of time until the bankruptcy is adjudicated, whatever the decision is, plus 6 months more. So I don't know how long a bankruptcy proceeding takes. And by the way, can I give you one piece of the word on bankruptcy? Some taxpayers will ask their enrolled agent about bankruptcy, all right? One of our members, or former members, he's now retired, a number of years ago gave some advice to a taxpayer on bankruptcy when he was in his office doing a tax preparation. And that guy learned the hard way because he got sued by the taxpayer, and $30,000 later, the enrolled agent was out of pocket, all right? I'm going to tell you the words, 3 words. When a taxpayer asks you about bankruptcy, here's what you should say. I don't know, all right? All right? And then you tell them, go to a bankruptcy lawyer. I don't know. Simple. And if they say anything, by the way, I did the announcement. Did anyone come up with the keys? Oh, no. Yes. The keys, was it settled? Or they're still out there? Yeah, they're still there. So did anyone, by chance, forget their keys? Car keys and a black book? They're outside. All right. All right. I think she'll bring them into you, all right? Or maybe. All right. But you know, that's where they are, okay? Take that in good advice. You know, if you don't know something, there's nothing wrong with saying it. But in this situation, you're protecting yourself, all right? So I think that's important. All right, after you have an issuance of a notice of deficiency, all right, notice of deficiency will extend the period. The phrase they often use is it tolls the statute. It means it's suspended for at least 90 days. And then if a taxpayer files a petition in a tax court, it extends it for the period of time until the judge makes a ruling. I mean, when I say the judge makes a ruling in tax court, many, many people go to tax court and never see a judge, but a judge always makes the ruling. Stamp it, all right? The appeals officer usually makes the decision, but So until you get a stamped thing, plus another, I think it's 60 days or 90 days or whatever it is it says in there. So be careful. This can easily get done. And the last one, assets of a taxpayer in control or custody of a court. Never had that before, so bypass it. All right, so I don't know. But there are other things that you do, or the taxpayer does with your help, that also extend the statute for collection, which takes it past the 10-year period. On the bottom of page 3, if you'd submit an OIC, it stops the period of this 10-year statute running. So if it takes you 18 months to get the OIC, maybe you get it or maybe you don't. That's 18 more months that went on to the 10 years, okay? If you, and you notice down at the bottom, it's kind of technical, but they give you all the periods. Don't memorize them. Just know they exist, all right? This next one on the top of page 4, though, is one that you need to consider, all right? And that is if you request a collection due process hearing, a collection due process hearing suspends the period for collection, all right? Some people argue, don't do a CDP request, do an equivalent hearing request. You know what, a CDP request, if the IRS, we're going to talk about it in a moment, so let's just say if you make a CDP request, what'll happen is an appeals officer, or they call them settlement officers, I think, will look at the case and make a determination of whether or not they should proceed with the collection in the manner that they're proposing, all right? But that is going to extend your thing. You have 30 days from when you get the notice to do the CDP. You can get the same kind of hearing, it's called an equivalent hearing, and you have 1 year from the time you get the notice to request the equivalent hearing. What's the difference between the CDP and the equivalent hearing? Well, generally the biggest thing is you have after the IRS makes a ruling in an equivalent hearing, all done. In a CDP hearing, you have the right to petition the tax court to make that the determination by the settlement officer is incorrect. Good luck on that, all right? It is virtually, I shouldn't say virtually impossible, but close to it, that when you see taxpayers bring CDP hearings to tax court, they almost always lose. Why? Because the judge is not there to make a determination of whether the appeals officer should have given them $10,000 off or not. The judge is looking to see, did the settlement officer follow the law in making the determination? Not whether it's the right determination or whether the judge, we don't care. One of the things you always remember about the tax court is the tax court always prides itself on saying, we are a court of law, not a court of equity. Meaning, you may have a good case, but it means nothing. Do you remember, some of you were here, maybe not too many of you, when Judge Vasquez from the tax court came. Was some of you here? We did a mock trial, all right? And I always tell people this case, and it's a little off topic, but I want to illustrate the point about the CDP thing. And he issued a case, it was called Gomez. And these people legitimately, they made like $65,000 in gross income. And these people legitimately tithed 10% to their church. They gave the $6,500. It was not in dispute. But they didn't have a letter. The letter that's in 170F paragraph 8 that says you must have a contemporaneous letter for any donation of $250 or more. And Judge Vasquez, man, he was a guy, Don actually had him speak to his class. I mean, this man went to community college and he, just kept going. I mean, he wasn't like a, Harvard law graduate. This guy was a man of the people. I mean, seriously. And when he wrote the decision, he said, I'm sympathetic. There is no doubt, and I'm paraphrasing what he said, there's no doubt in my mind he gave the $6,500. But the law is the law. You didn't have the letter prior to filing your tax return, you lose. All right? So that's why when you go to any kind of tax thing, remember the judge is not going to really care about whether or not the appeals officer could have done a better deal. They're only going to ask, did they follow the procedures that they have to follow? Well, the rule says it has to be contemporaneous, and contemporaneous means it has to be in your possession before you file the return or April 15th, whichever comes first. Okay? So if you file late, you got to have it by April 15th. If you file it on March 1st, you have to have it by March 1st. Okay, and just going back now to this equivalent hearing, you don't have that judicial right, but it doesn't mean anything. It really doesn't. So I would say to you, think hard, but here's the problem, and it is a problem for an enrolled agent. A collection due process hearing is a right the taxpayer possesses. It's a statutory right, all right? An equivalent hearing is an IRS administrative, we're good guys. So it's very hard for you to just dismiss this right the taxpayer has. You follow what I'm getting at? All right, I'd always tread carefully and make sure that you proceed appropriately. Because once you, it's like the taxpayers have some rights, and this is one of them, and I would be careful that I didn't try and dismiss it without thinking. Well, that IRS, those guys are pretty nefarious. All right. Now, Don raises a point that it's 30 days from the date of the letter, not the date of receipt. So be careful that you pay attention to that. All right, the next one is if you ever do any innocent spouse relief, the statute is told for that also. And if you do any 9/11 applications for a taxpayer assistance order, the statute would be told for that as well. Yes. All right. So Catherine is just suggesting be careful with the assessments if you have anything with an injured spouse. Make sure you're paying attention to what's going on there. All right. On the bottom of page 4, here's an important point. It's the notice of federal tax lien. Is the notice of federal tax lien required? Is it required, the notice of federal tax lien? And the answer is no. It's not required. The lien exists. Why is it so important, though, for the IRS to file the notice of federal tax lien? Right now, the taxpayer owes $10,000. 6 months have gone by. The notice of demand was made. The taxpayer refused. When was the assessment made? 6 months ago. All right, the lien has existed for 6 months. Who knows about the lien? Nobody, except IRS and taxpayer. So, what's the purpose of the notice of the federal tax lien? It's to put them in line to collect money. The law says, the taxpayer has a mortgage. Does the bank have a lien on their house? Yeah, they owe money. So here's the taxpayer. They got the bank. He took a car loan. Does the Lexus Financial Services have a lien against that car? Yeah. And they go in order, you know, first in, first out. So if the IRS wants to get in line, all right, and by the way, they don't go to the top of the line, they just go in line, they have to file the notice of federal tax lien, all right? And the notice says to the world, John Doe, all right, owes us money and it refuses to pay, all right? Now, that lien used to be a lot worse because at that time, what happened with the lien, not only was it publicized, but where did it go that it hurt people significantly, went on their credit reports. You know, Experian, TransUnion, and the third one I've named escapes me for a moment. They would get reports. Their bounty hunters would go down to the county clerk and see who's got, and it would go on their credit report. They don't do that anymore. So, you know, but the notice still puts the IRS in line. Let me come back to you, Don, in a second, all right? It puts the IRS, and remember, there's an ordering. First, bank, this. If the IRS wants to get in, they have to do the notice. Will other people come underneath them? Yeah. That's the general rule. You see that can change, though, a bit, all right? But anyway, just take a look on page 4. The general rule is that at this moment in time, the service doesn't bother to file a lien unless the assessment is $10,000 or more. That's the general rule. Can they put a lien on a smaller amount? Of course they can. You owe the money. But that would probably take a manager to approve it. There might be a reason. They may be after somebody, and I don't know. But the general rule is the notice doesn't happen until it's $10,000, all right? And I think what's important is the second paragraph from the bottom. The filing of the notice of federal tax lien is not a step required to give rise or to perfect the lien against the taxpayer. The act of filing protects the government's right of priority against certain third parties. All right, the filing of the notice of federal tax lien is constructive notice to those persons that the lien exists. In essence, the lien is no longer silent. Okay? That makes sense to everybody? That's the purpose of it. It's not required in the sense of perfecting the lien, as it says. It's only to get the IRS in line. Where are the... And by the way, have you ever seen like a service? They mail you things that we can give you the liens of all the people, like in Suffolk County, or I live in the town of Brookhaven. And so all the people that owe liens in Brookhaven, for $18 a piece, we'll send you, and you can do that. I'm sure everyone has gotten some of those solicitations because they realize it's now a matter of public record. These people owe money, and they don't want to deal with it. They're just trying to make some money by telling me, hey, here's a possible client for you, you know. So that's always the situation. And there's some different rules for real property. The notice is filed in the county clerk's office where the property is located. If it's against personal property, the notice is filed in the county where it's the residence of the taxpayer. If it's a corporation or partnership, it's where the principal executive office is. And if you're overseas, it's made a determination for purposes of the filing that the taxpayer is deemed to live in Washington, D.C., and they file it with, there's a special office there where they do that, all right? One of the things to keep in mind is there can be errors in the notice. Like, my name is often misspelled. You know, my name is Degen, and I'm going to tell you a good way to remember this. If you're a good speller, spell degenerate. And the first 5 letters of degenerate are D-E-G-E-N-E-R-A-T-E. all right? So, a lot of people misspell my name, though. They say Degan. Matter of fact, I just mentioned about Krish. When I got the certificate from the tax court, they misspelled my name. Can you believe it? I called up, and I could hear the poor woman. I mean, you know how you can hear someone over the phone? She was mortified. I mean, truly mortified. I could just hear, ah! I had it the next day, I think, corrected. But if there's an error on the lien, all right, like a misspelling or sometimes in a first name, if your name, I forget what it was, but suppose your name is Alphonsus and they used Al. It's not terribly important. As long as the lien reached the person and the error on the lien didn't interfere with a proper assignment to the person and receipt. So just keep in mind, if you ever find anything like that, it's not terribly important, all right? Okay, on page 6 is just a little bit more about the collection due process hearing, all right? And understand something that, remember yesterday if you were here, we talked about the right to levy. And there are 2 sections in the Internal Revenue Code's section 6331 is where the levy is, where the real levy rules are. And then there was other one, 6330, which was put in by the RRA 98. And the same thing exists with the lien. The lien rules start at 6321, really. But when they did RRA, they introduced Code Section 6320, and 6320 provided, same as 6330 did, 6330 is for the levy, and 6320 is for the lien, and they provided the taxpayer with the right to contest the lien. Not to contest the lien is already there, to contest the notice. The problem is the notice has already been filed. And the law says in 6320 that the IRS must send a certified letter to the taxpayer within 5 business days after the notice has been filed, telling the taxpayer that you have the right to contest whether this lien should have been filed. I think they use the phrase sometimes, the appropriateness of the lien, all right? Good luck on that one, too. I mean, I don't think you're going to have much success, but it gives the right, all right? What might have happened is if a taxpayer does it, they may be able to show the appeals officer or settlement officer, this was already settled, I got this, or that was my uncle who has the same name as me, kind of thing. But generally, it's not going to be too helpful, but it is a requirement. Then you do have 30 days, all right? And they are required to tell you about the fair hearing. And remember, the last thing down there is the notice that the statute is suspended during that period. And once again, I'm not telling you to give up that right, but sometimes you gotta, maybe the equivalent hearing is better. Okay. Any questions so far before we get to some other stuff? All right. So the question is now is you got all these guys in line, right? Congress has created. They realize in the business world, in the real world, we can make these rules, but people operate sometimes, without knowledge of the lien. If you hire a plumber, the first thing he doesn't do is go down and see whether the taxpayer has a lien on the house against him, right? Other than a mortgage, he doesn't look for an IRS lien. So what the IRS did is they created some specialties in terms of the priorities. Some of the priorities exist before the notice of federal tax lien, and the so-called super priorities are priorities that exist after the notice of federal tax lien. So, and I'll show you what I mean by that, but let's suppose you have a federal tax lien, right? And here's the list of taxpayers. Under one of these so-called super priorities, to be discussed, that even if you're a super priority, you don't go to the bottom of the list, you go somewhere in here, all right? You go ahead of the IRS. Who made that decision? Congress, all right? Right or wrong, they made the decision. And that's what happens. So when you talk about a super priority, or even like a mechanics lien has great priority, here's the list. Here's IRS, all right? I don't have a third hand, so here's IRS, all right? So what'll happen is you can put other guys in between, all right? Here. That's what happens with these lien priorities. So take a look on page 6, all right? And as I mentioned there to you, Congress recognized the difficulty in conducting business when creditors were unaware of the service silent lien. Consequently, they enacted 6323A, which provides the lien imposed by Section 6321 shall not be valid against any purchaser, holder of a security interest, mechanics lien or judgment lien credit until notice, therefore, has been filed. And in short, the notice of federal tax lien must be filed in order to have priority over these creditors. And what's interesting about that, let's suppose that those 4 that I mentioned, unless there's a notice, they don't have to worry, even if they knew the lien was in existence, all right? So suppose the taxpayer says, listen, I got some tax problems here, blah, 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 and the mechanic says, all right, that's your problem, not mine. So let's say it's the plumber doing a $5,000 plumbing job, all right? And he knows that the taxpayer, the homeowner, has this lien against him. Doesn't make any difference. They still can go ahead in terms of getting their money, all right? So even before, and there's a revenue ruling on that, which is interesting. And this is one of the places where the IRS, sometimes we yell at them a lot, but it's kind of interesting that even if they knew the lien existed, they're going to get this priority in the line, the mechanics. The mechanics liener is the biggest one that you would see. Someone did a job for somebody, built the house, did plumbing, repairman of that type. And even if they know, they still go ahead, all right? And on the bottom of page 6, there's a revenue ruling, and I think this is a kind of important idea where the IRS, I don't know if they used their head or just could reach no other decision. All right? It says, when a notice of federal tax lien has not been filed, does actual knowledge of the statutory lien affect the lien priority of the mechanics lien or whatever? And on the top of page 7, the revenue ruling cites this court case. It's called Beaver Run Coal. And in there, the court held, this was in the Third Circuit, the issue was whether a mortgage lien had priority over the government's statutory lien as to particular property in the taxpayer's possession. So the mortgage was there, and the IRS, they gave the mortgage, all right? And it says, the court held that the mortgagee was protected against the statutory lien, even though the mortgagee had actual knowledge of a possible tax liability because the notice had not been filed. But what the interesting part is, that's against the IRS. That's a negative action, really. And so, but what the IRS mentions in the revenue ruling, almost fell on my own feet there. All right, what it mentions in the revenue ruling is that despite this, when Congress changed the lien law in 1966, it had the opportunity to change that rule, and they failed to change it. So therefore, if Congress didn't change it, The IRS is not going to change it. You're making sense to what I'm saying? All right? So if you look at the holding, it says for purposes of IRC 6323A, a purchase of blah, 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 all right, is protected against a statutory tax lien for which the notice has not been filed, notwithstanding actual knowledge of the statutory lien. So understand, certain groups are in good shape, all right? Now, in addition to that, what happens after the notice is filed? There are certain situations where Congress has deemed, all right, here we are, coming down, here's the IRS, we filed our lien, and now anyone else that has a lien is going to come after us. Not so, not necessarily. What happens is they introduced the code section where they created 10 super priorities, 10 events, 10 situations where the holder of the lien would get a step above the Internal Revenue Service, okay? And if you look at them on page 7, those are the 10, all right? And I think about halfway down the page, it says there in 6323B, special protection for certain competing interests, giving them priority over the federal tax lien, even though the interests come into existence after the filing of the notice, all right? And the 10 of them are there: securities, motor vehicles, personal property purchased at retail, personal property purchased in casual sales, I can't say that word, possessory notes, liens, whatever it is. All right, real property tax and special assessment liens, residential property subject to mechanics lien, attorney's liens, certain insurance contracts, deposit secured loans. We are not going to go over all 10 of those in detail. There are a couple I want to mention to you, but understand that Congress has created a situation where they feel, whether right or wrong, whether you agree or disagree, that certain interests should come above the federal tax lien in terms of being able to pay it off. All right? Does that make sense to everybody what their intention is? And just for a moment, on page 8 and page 9 and page 10 are all these guys. A couple of them I want to mention to you. Not all of them, because quite frankly, you're not going to see most of these in your career, all right? And I just think what's important is to understand that you're once in a lifetime, you know, we have these once in a lifetime floods all the time, but they seem to be like once in every 10 years. So if I say to you once in a lifetime, maybe you'll never see it, but maybe you'll see it more than once. So on page 8, when they talk about securities, stocks, bonds, debentures, and so on. So if you buy something and there's a federal tax lien, all right, you're in good shape as long as you didn't have actual notice, all right? As long as you didn't have actual notice. So if you buy something, you know, a stock from somebody and you didn't know there was a lien, even though the lien has been publicized, you are okay, all right? Same thing with a motor vehicle. All right, if you buy a car, let's suppose you buy a car from a neighbor, and there's a tax lien against the neighbor, all right? As long as you didn't know that there was a tax lien against the neighbor, you can buy that car, all right, and without worry that you're going to be involved. Property at retail, that would mean if you had a business and you were selling goods and someone come on and bought them, all right, there's a super priority there. It's interesting, number 4, personal property purchased in a casual sale. Garage sale, tag sales. Suppose you go to a garage sale and pay $1,000 for some painting that you think is worth $100 million, all right? As long as it's under, what is it, $1,940 right now? Under $1,900, you don't have to worry about the notice of federal tax lien, all right? I mean, it's amazing what they go through in this. They actually thought about garage sales, all right? And as long as you don't actually know, that's the key. All righty. And there's a couple others, but I do want to mention to you number 8. This is on the bottom of page 9. These are attorney liens. Why do I mention attorney liens? Because whether they knew or didn't know, it makes no difference. The lawyer's going to get his money. He's going in there ahead of the IRS. All right? So if you take a look, are any of our friends back there attorneys? I'm sorry if I don't know if they are from New York State, DTF. All right. So this super priority protects an attorney who under local law holds a lien on a contract enforceable to a judgment, all right, for obtaining a judgment, even if the attorney had actual knowledge of the filing. And I guess it's always nice to pick on lawyers, you know, right, Kevin? We all have a lot of fun with doing that. But it kind of makes some sense, though, because if a lawyer is supposed to protect your interest and a taxpayer goes to someone, I think even though we say tongue-in-cheek, it shouldn't happen, it does. All right, and quickly on page 11, I just want to mention the 11th super priority. But Frank, you just said the Internal Revenue Code of 6323B says there are, or C, whatever it was, has 10 super priorities. I went like this, right? But the IRS has determined via revenue ruling that there's another situation which is close enough to these guys that they made it a super priority. All right, and it's in revenue ruling 68-57. And basically what it is this. You can have what's called a purchase money mortgage, or that's called a PMM, or you can have a purchase money security interest, a PMSI. If you have one of those, you are considered to be a super priority, number 11. What is a PMM? Well, let's suppose I own a house and I sell it to somebody, and I'm going to finance the sale of my house. I'm going to hold the mortgage, not a bank, all right? That's a PMM, all right? I'm protected if the person had a lien against them, all right? Does that make sense? That's a PMM. What's a PMSI? That would be, let's suppose I go and I buy a TV screen that big and it cost me $8,000 from, I don't know, they have PC Richards up here, or maybe that's just a Long Island thing or whatever, from your local appliance store, and you finance it, all right? The retailer now has a PMSI, all right? Because PMSI are for personal property, PMM are for real property. So what they do is they create a super priority that they're not underneath the IRS. This all makes sense? I mean, it's I'm saying a lot in a short period of time, but the important thing is to understand that this lien is not just a simple little matter. There can be a lot of stuff in here. I hope I know the answer to your question. Yes. No. I have it. Yes, certainly. I have a lien against the buyer, right? If I sell the house and I hold the mortgage, I have a lien on that house, correct? Everyone agree with me? My lien goes ahead of the IRS lien. All right, that makes sense? All right, that's what if I wasn't clear, I'm sorry, but that's what it was, okay? All righty. Now, those are some of the conditions, but, you as a enrolled agent, you want to be able to help the taxpayer navigate this whole system. Let's suppose the lien is in place. Is there any relief from the lien? And the answer is yes. Under some circumstances, there can be some relief, all right? And we're going to take a look at that. It's on page 12. And you notice in bullet 5 there, it says relief from the federal tax lien. And we're going to take a look at basically, it says 5 of them there, but one of them we're just going to sort of gloss over. But Code Section 6325 provides the mechanisms for relief. The first one is the biggie, the release of lien, the discharge of lien, the subordination of lien, the non-attachment of lien, and there is another one, and this is not under 6325, it was under 6323, it's withdrawal of the notice of federal tax lien. I'm going to talk about that one first, just quickly. A few years ago, when we said when a lien was filed, or the notice was filed, it went on your credit report, all right? And the taxpayer advocate was involved, and for the most part, this credit reporting hurt people with lesser means. Wealthy people generally don't have, generally don't have some of these issues. So the burden was falling on people with lower economic assets, and so the taxpayer advocate pushed hard for a withdrawal. Why didn't the taxpayer advocate just push hard for a release of lien? Because it's statutory. She couldn't do that, all right? Because the lien stays until one of two things, right? Taxpayer pays, or it's unenforceable by a passage of time. No ands, ifs, or buts. If anyone tells you they can release a lien, they know what they're talking about, all right? What the withdrawal of the lien meant, not that the lien went away, but the public notice went away. Does that make sense? That's what the withdrawal was designed to do, to help people. If you have this lien against you, and you're of limited assets and means, and you go to buy a car, what's going to happen to your credit rating? And you're going to pay the car loan at, and I'm making up the number now, right, at 10%, whereas the ordinary guy going into the showroom is paying at 5%. Why are you going to pay 10? Because you got to own a lien against you. They know, they perceive you as a deadbeat. Right? I mean, that's the reality. So the taxpayer advocate was big on this, that she wanted to have the withdrawal, all right, because it would remove people. And the IRS has it. I don't know the statistics involved in it, but it's not as important today as it was when the taxpayer advocate was advocating for the withdrawal, because they don't put it on your credit report anymore. 5-6 years ago, they stopped doing that. So if it's not on your credit report, it's not, when you go to buy your car now, I don't know if they ask you if you have any liens. They may on the application, which might be a problem, all right? But if they don't ask you on any application, and they do an Experian or a TransUnion or Equifax, whatever those things involve, and they do a run, they don't see the federal lien anymore. So it's not as bad. But anyway, just look in the box. It was added as part of TBOR. Everyone know what TBOR stands for? Taxpayer Bill of Rights. All right, this is TBOR 2. And by the way, do you see Karen Bear frequently at all? All right. Bear with me, folks, 1 second. I was so disappointed. Let me see if I can find it now. Just bear with me, all right? Older guy, you got to cut him a little slack, all right? I had something for Karen. Oh, here it is. Karen Baird, some of you may or may not know, is my codophile, all right? So I had this for her. This is taxpayer rights, and I completely forgot about it until we said TBOR 2. So would you give that to Karen? Tell her I hope she feels better, and I'm glad I asked the question. All righty. So under the Taxpayer Bill of Rights, the the ability to withdraw the lien was inserted, all right? But I want you to notice what I already said orally, but it's there, that a withdrawal of the notice of federal tax lien differs from a certificate of release, and the two cannot be used for one another. A withdrawal only removes the effect of the notice, whereas the certificate of release releases both the notice and extinguishes the statutory lien, okay? So everyone understand the difference now? Withdrawal is not so important. People don't ask for it much anymore. It was a good job by the taxpayer advocate. I think it, you know, it really, really was worthwhile, but fortunately, the collection procedures are different now, so it's not as important. All right, so the release of lien. All right, this is going back to something we said at the beginning. All right, this is in 6325. All right, it says the release of lien subject to blah, 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 blah. All right, the lien will be expired if the liability is satisfied or unenforceable. All right, notice there's one little alternative. It's really basically the same as satisfying, and that is if you put a bond. All right, I guess if you are contesting the tax liability and you don't want to admit the liability, but you want the lien to be released, you can give a bond equivalent to the amount you owe without admitting guilt, so to speak. All right, you follow what I'm getting at? You know, you see these things on the newspaper. The guy pleads guilty but doesn't admit he did it. You know what I mean? One of those deals. So that's sort of like what this is. You can post a bond, but financially, as I said, if you owe $20,000, the bond is $20,000. It's not like, you know, you can put a 10% down and get the lien released. Not going to happen. All right. So with the bond is in effect satisfying the conditions. All right. And on the top of page 13, all right. Just what we've been saying is that, in summary, the code provides for a release of lien only when they satisfy the liability or the statutory period for collection has expired, or the little exception of the bond. But financially, there's no difference between them. Okay? So that's the withdrawal of lien, release of lien. Everyone's hoping for. A couple times in my career, I've had taxpayers write out the statute, all right? And if you look at their transcript, it does say no longer enforceable, or, you know, a couple of transcripts said different things, but the same thing, if you understand what I'm saying. You know, we can't collect anymore on this, so it's going away, all right? All right, but there are a couple other things that can happen which you may or may not be aware of, and let's take a little bit of a look at them. And I think the discharge of lien is probably the most common that you may want to be aware of. And what the discharge of lien means is you have, let's suppose the government has a lien against you. Where's the lien attached to? All property, right, and rights to property. So if the government has a lien of $50,000, you know, that you will have an assessment, it's against your house, your car, your wife. Oh, no. I wish. All right. I've been married a long time. You can tell by the smile on my face, right? But it attaches to everything, okay? Suppose you as a taxpayer have a second home and you would like to sell it, all right, because it's just no longer used. But there's a lien on it and no one wants to buy the house because they know they got a problem with the IRS. So what you can do is you can file an application for a discharge of the lien against that specific piece of property. It's usually typically used in a real estate transaction. You can actually do it against your own home, all right? And what happens? How do you get the discharge? Well, there are different criteria. Because remember, you're not going to extinguish the lien. The lien is still going to be there. It's just that you're going to take the lien and all your property, you're taking a piece of property out, and that one is free. That's what the discharge does. Everyone make sense, everyone? All right. And if some of the criteria are interesting, all right, and all these, remember, all these reliefs are in Code Section 6325. So if you look about one-third of the way down, discharge is the process of removing a specific piece of property from the federal tax line. A certificate of discharge removes the lien from that property. And notice what the IRM does, what I just said, but I want to re-emphasize it. The IRM notes there is a fundamental legal distinction between the release of a federal tax lien and the discharge of property. The release extinguishes the federal tax lien itself. It's gone. All right? In contrast, a discharge will leave only a particular piece of property unencumbered by the federal tax lien. And a discharge must meet one of the specific conditions of 6325B. You're going to see them. There are 4 or 5 of them coming down the line here. All right? After the discharge of specifically described, the lien continues in full force and effect on all other property or rights to property of the taxpayer. All right? Everyone with me? Okay, so how can you get a discharge? The first method is called double the sum method, all right? Well, let's look at what it says, and you tell me what this means, all right? You'll be in good shape if you do. All right, the remaining property of the taxpayer has a fair market value that is double the sum of the amount of the federal tax lien, plus other encumbrances that have priority over the federal tax lien. That's the double the sum method. Make sense, everybody? If you're lying, if you're shaking your head, yes. All right, it makes no sense to anybody. It's easy. Well, I'll show you in a second, all right? That's the first one. The second one is on page 14. An amount not less than the value of the government's interest in the property is paid in partial satisfaction of the liability. What that would make, the most common situation would be like with a piece of property. If you have a large lien, a large assessment against you, and you sell that vacation home, you would take the money that you get from the vacation home and just apply it to the lien, if that could against the assessment, if that would work, all right? But that sometimes doesn't have to be as big as that, and we'll see in a moment, all right? It is determined, the third one is determined that the interest of the United States in the property to be discharged from the lien has no value. To qualify, the taxpayer must be divested of all interest in the property, all right? How can that happen? How can there be no value? Well, you might have a mortgage. Suppose you have a house that's the fair market value. And by the way, they don't use actually fair market value in making some of these determines. They use what is called forced sale value, all right? Might be like a 20%, there's no, you're not going to find this written anywhere, but sort of like a 20% discount, if you will. If you had to sell your house and you want, depends where you live, $400,000, I'll just use that number, all right, and that's the fair market value. Maybe, people always, I don't know, do you have clients like after 2008, 2009 property went down, or even later on with COVID, people would say, well, my house is worth $600,000, but I can only get $500 for it. Well, how is it worth $600? It's worth $500. You get, this magic thing like somehow God is punishing them. Fair market value is what a willing buyer will pay a willing seller. That's what it is. All right? So let's assume that you could have a fair market value of $400,000. Typically, they don't use that number in some of these calculations. They use the forced sale value. Let's suppose the house is truly worth $400,000. But, you know, you got a family illness in Chicago, you have to move there, you know, you might be forced to sell the house, and even if you didn't have a lien, you might have to be forced to sell the house. So, like, instead of $400,000, the IRS might view it as $320,000. You know, I've seen 80%. There's no hard, fast rule, but I've seen 80% as kind of the number that a lot of people use, all right? So there's two others, but they're so obscure we're not going to take a look at them, all right? But I just want to show you the double the sum method and the other one, okay? So if you look on page 15, and by the way, on the bottom of page 15, if you have a highlighter, there is the publication. It's publication 783. That guides you, gives you the instructions for how to seek a discharge. There is a form. Of course there's a form. This is the IRS. All right? The form is 14135, and it's an application for a certificate of discharge of property from federal tax lien. On the bottom of the page is something kind of important. Authority to approve discharges is limited to advisory and insolvency group managers as per delegation or blah, blah, blah. All right, a couple of things in there. In the Internal Revenue Manual, I just mentioned this as an aside. I always like to give people tidbits so they go, oh, I didn't know that. All right, in the Internal Revenue Manual, all the policies of the Internal Revenue Service are in section 1.2 of the Internal Revenue Manual. All right, policies written. You know, everyone always talks about that 6-year policy for collections. It's in there. Policy 5-133. It says 6 years. All right. It's not that simple sometimes, but you know, those are where the policies are. Included in the policies in another subsection are the delegation orders. What does that mean? Well, the commissioner of the Internal Revenue Service doesn't make the decision on the discharge of your property if you have a lien. So, but they are a hierarchy of who can do these things, all right? Only certain people can do certain things. Like a revenue officer has much more power than a revenue agent in terms of what they can do. You know, revenue officers are charged with getting tax returns from people that haven't filed. Revenue agents may help, but they're not, that's not part of it. They're different things. But all these policies, all these delegations are in there. So what in terms of lien release, in terms of discharge, in terms of subordination, there is a central group where they look at this, and they call them advisory. And so these are people that are not like, you know, PPS, call me on the phone, can I get this discharge? You got to go to the specialists and follow the rules. So when you hear advisory, all right, that's what they're talking about, all right? So let's look on the top of the page, 15. If you wanted to convince advisory that this property is eligible for discharge, here you can use the double the sum method. Let's suppose that the federal tax lien is $10,000, all right? You see the example in the halfway down the page? There are other encumbrances senior to the federal tax lien. That's probably the mortgage, right? That's $50,000. Real estate tax is a super priority. So let's assume it's $1,000. That goes above. So the mortgage and the real estate taxes are above the IRS in a line on what we said. So how much is there in federal tax lien plus priority encumbrances? Is $61,000. If you want to get a discharge using this method, what does all your other assets, besides the piece of property you want to discharge, what does it have to be? $122,000. It's got to be double that amount, okay? So they'll discharge the property to you. Why? Because they realize there's enough money there, enough assets, that we're not going to get, hung out to dry here. Everyone follow what it is? All right? So that's called double the sum. You take the lien, which you already owe, plus all the other encumbrances which are in existence, and if you double that, if you have assets, you are good to go. All right? The second example, and by the way, this comes from the IRM. This is not my made up. This is IRM. Yes, dear. By the way, I told Betsy yesterday, and she was lucky. It was under $600. So, only lucky in the sense that there would be no paperwork. I know you, as a true professional, realize Code Section 61 says gross income from whatever source derived, including gambling. Yes, go ahead. She won, for you guys, she won $550 last night or something. What, $540? I'm sorry. That makes a difference. Go ahead. It would be all the property, because if you have, Betsy is saying, suppose you have, the $50,000 is not just the encumbrance necessarily on the property that you're looking to get discharged. So it would be if you had multiple mortgages, that would all be included, because those mortgages are in line higher than the IRS, okay? So, in fact, the property you want to discharge may not have a mortgage, It's a good question, okay? All right, Betsy, we won't ask you next April 15th. We will just trust your good judgment on there's an ethical consideration. I hate to get off topic, but this is a good story. All right. I used to speak for this guy, Brian Gates, in the American Academy of Tax Practice, and I went to Las Vegas, and my wife told me to spend $50 on a dollar slot machine, had to be wild cherries, all right? So I went and I put the $50 in, and sure enough, won $2,000, all right? Now, here's the ethical question. Do I tell my wife? I could have told her, honey, I put the 50 in. Didn't work. So, not only did I tell her, the fool I was, I gave her to count it out to $2,000, because they don't give you checks for that amount of money, and I had to pay the tax on it. All right, so, because they gave me a 1090 W-2G. All right. There's a little bit of lossing in everyone, so we're not going to report Betsy whatsoever. All right. All right, I don't know how I got off on that, but anyway. All right, this example illustrates the value of the government's interest. This is from the IRM, and it shows you what that means. I mean, obviously, if the value is dollar for dollar, it's no issue. But look at this example to see if that makes sense to you. Taxpayer wishes to sell a $100,000 home with a $75,000 prior mortgage and a $30,000 tax lien against it. Assuming the cost of the sale are $10,000, all right, title charges and so on, the IRS will discharge its lien for $15,000. Why will they do it so little? Because there's no value in that property except to the extent of $15,000. So the property they're trying to discharge, they're not losing out on it, because right now, what could they collect? They got a senior mortgage against it, right? And in the discharge things, you are allowed to have closing costs as part of the deal here. So that's what that means. They would discharge that property. Obviously, the taxpayer would have to pay them the $15,000 on the closing, all right? Because that's all the value in it. The taxpayer is not gaining anything here. If he saw that there was no lien and he sold it, what would the taxpayer, he or she, have? $15,000. So you're just giving it to the IRS, all right? So better to get something than to get nothing, right? And they understand that that 10-year clock is always ticking, all right? So that's a discharge. A subordination is a little bit different. This is on page 16. So discharge removes the property, all right, based on that. What subordination does is it allows the taxpayer to maybe to manipulate something. And here's the line now, remember. Here's what they owe, and all the guys are in line, right? And the bank is here, the IRS is here. Taxpayers say, maybe I can subordinate the loan. I have something down here underneath you, and I'd like to bring it up here. I'll give you some money to do that. Is that making sense? That's basically what a subordination is. It takes you and it moves from a different spot in line. Because remember, mortgages, all right, are in line, and they could be further down. So what subordination does, and this is on top of page 16, subordination is the act or process by which one person's rights or claims are moved voluntarily to a position ranked below those of other claimants. So what the IRS does when it subordinates, it agrees to move down in the list. Why would they do that? It may be in their best interest. They may see that they're going to get some money that they would never get in a million years. All right? Remember, better to get something than to get nothing. You know, the classic example of that were installment agreements. When you had an installment agreement, what did the government used to insist on? If you couldn't pay it in full by the end of the CSED meaning the collection statute expiration date, if you couldn't pay it by full payment by CSED, we don't want your money. Well, that was the stupidest thing you ever heard, right? So if someone said, you know, I'm never going to pay you the $50,000 I owe you. Well, give me an installment agreement and you'll get $35,000. No, we don't want that. No 50? Nothing. I mean, that's what they were saying. It was insane. So then when they did PPIAs, partial payment installment agreement, the government came to its realize something is better than nothing. So you get the same situation. I owe you the 50 grand and you can get 35 grand. Only a fool would say no, right? And, no comment then. All right. So just keep that in mind, all right? Okay. So, and it's just there that if the payment is equal to amount with respect to which the tax lien is subordinated, or the service believes that the subordination of the tax lien to another interest will ultimately result in an increase in the amount realized. I don't think that Part B is often achieved, all right? And by the way, I haven't heard one peep out of a former NTPI instructor about liens. Are you sleeping back there? Or? Oh, right, I'm serious. I'm dead serious. All right, Don mentioned something that's worth noting. If you file for an installment agreement, the collection statute, for only a short period of time, though, it's not like I don't want to say that. I guess I can. It's not like a biggie where it takes you really far out. I think it's 30 days plus the period while the installment agreement is in thing. So Don brings a good point that if you file, there might be that a slight tolling of the thing. And you know what's interesting is in a lot of stuff where the IRS talks about tolling, they never talk about the IA because it's a little complicated and it's not as simple. Just, you know, if it's a CDP, it's 90 days plus a period of time, blah, blah, blah. You know, on the installment agreement, it's a little bit, but it's a good point. Thank you. Anything else you want to share with us?
No, I think you're doing
all right. Thank you. All right. Seriously, Don used to be in the good old days of NTPI in level 2. I don't know if any of you ever participated. He was an instructor on the, didn't say much correct, but otherwise, I couldn't resist, Don. People always say to me, why do you pick on Rosenberg? And I say, because he loves it. If I didn't pick on him, he would think I'm mad at him. All right? All right. All right, thank you. No, seriously, Don, thank you. All right. So that's what subordination is. It provides a service with flexibility, all right? So typically, the notice of federal tax lien would be subordinated to a lender loaning money to the taxpayer and securing the loan with a mortgage. In other words, this is going to happen in really limited experiences where there's going to be a bank involved, you know, a lending company, I'm going to call them a bank, and they're willing to give the taxpayer some type of mortgage, but they're not willing to be underneath the IRS in terms of their priority. So the bank will say, all right, you put us ahead of you and we'll make some accommodation, all right? And it doesn't always have to be a dollar-for-dollar thing. This is an example from the Internal Revenue Manual. Once again, if you look on page 16, it says the taxpayer owns a home worth $100,000 with an existing mortgage of $50,000 and an IRS tax lien of $60,000. The IRS might subordinate if the taxpayer gets a second mortgage of $25,000 and pays the amount to the service. The new lender now gains a priority. Now, you see, the tax lien is $60,000. There might be, some of this may not be as appropriate now because what happened to mortgage rates, they went well up. But it might have been, you know, a while ago where you could say, listen, I can pay part of this. I'll get a cheap mortgage, you know. It's a little trickier now. But that's what will happen. The IRS will, you know, like a home equity loan or that type of thing, get $25,000, pay it towards the bill. The only thing that the service is doing is letting that bank go ahead of them. Does that make sense to everybody? All right. And there is also a publication for that. It's publication 784. This is on the bottom of page 16. All right. It's found in publication 784, and the form is 14134. Once again, the only people that can do this are advisory. I think the lien unit is in Cincinnati Service Center. Does that sound right to you, Don? I don't know. I think that's where it is, but you contact them. But if you reach them on phone, by the way, they are quite helpful and quite knowledgeable, all right? You are not talking to don't take this ever in a demeaning sense. I don't mean this. You're not talking to a PPS person who has limited training, you know, and has a certain role to play, but these people in the centralized units are experts. I mean, so this is all they do, and they can be helpful to you. Mayor? All right, so Mary's talking about releasing a lien from New York State, right? And she has I don't want to say contact, but name of somebody. So if you have anyone like in New York City, where this might be, you know, give Mary an email shout, and she'll only charge you $500 for a referral. But no, seriously. If, you know, she has the name of someone in the IRS who is helpful, all right, and that's good. Okay, let's take a look on page 17, the non-attachment of the lien. This doesn't happen too often, but it can happen, and that is where the lien doesn't, where property was, let's say, jointly owned, or there's a divorce, or there's a similar name, you can actually get a certificate that says, hey, I'm Dan Kosher. I don't owe the money. There's a guy up the street with a guy with a similar name. He's the guy that owes the money. So you can get a non-attachment. This is on top page 17. They may issue a certificate of non-attachment the service determines that a person other than a taxpayer may be injured by the appearance of the service's notice of federal tax lien. Situation typically arises when the name of the taxpayer is similar or identical to that of a taxpayer identified on the notice. The service files a certificate in the same office that the service filed the notice. It is conclusive that the lien does not attach to the property. Now, obviously, some names are quite common. Other names are not. So if your last name is Smith or White or Johnson or, there's a lot of Smiths, there's a lot of Whites, there's a lot of Johnsons in the world. If your last name is discombobulous, there's probably not too many of you guys, all right? So there is a distinct possibility where people can do this. And the IRM gives a couple of examples, all right? The second one is kind of useful, especially. It says, the first one is this: suppose Jack A. Wilson has a federal tax lien outstanding against him. Jack R. Wilson is in the process of selling a parcel of rental property. The IRS mistakenly files a notice of federal tax lien against Jack R. Jack R. may obtain a certificate of non-attachment certifying that his rental property is not subject to the tax lien outstanding against Jack A. Now, that obviously can happen relatively easily, that people can get mixed up, so you can do that, all right? The second example, though, I think is a better one that they have, and it says, Jerry James had a tax lien due to unpaid liabilities. He married Mary, and they bought a house at 150 Main Street. Mary also inherited a house on 200 Main Street. They later divorced. Mary wants to get an equity loan on 200 Main. The title company sees the lien and raises questions. Mary may apply for a certificate of non-attachment related to any lien in existence on 150, all right? Because sometimes when they have joint married couple, they'll put the lien with both names on there. That happened to one of my clients, and we were able to get it that it was the lien only went on his half, but that can happen. So Mary's in a place where this house has the lien on it, only in his interest, all right? It doesn't really relate to both of them, but the title company doesn't want to know that. They don't have any enrolled agents working for them, probably, all right, to explain the difference. So she can get a certificate of non-attachment. How do you get it? You got to contact advisory, all right, and tell them the situation, all right? And notice it says the certificate of non-attachment is not related to the discharge of property or the release of the federal tax lien. The certificate is used only when, as a matter of fact and law, the federal tax lien never attached to the property involved because the taxpayer did not own it. And there is a publication, it's publication 1024, which explains the details and how to get a certificate of non-attachment. Okay, we got 5 minutes left. We're right on target. I'm going to address Don's question right now, or Don, feel free in a moment to jump in, all right? At one time, liens, when they were unenforceable, you would get a certificate of release of lien. Now, if you look, and it's right there on page 17, you see a thing in the box? This is what the tax lien form, by the way, is Form 688Y, and it contains a box with this the content. It says, for each assessment listed below, unless the lien is refiled by the date given in column E, this notice shall on the day following such date operate as a certificate of release as defined. So what they do, the lease is said to self-release. They won't send you a form. You can ask for one, all right? And you have to ask advisory. But as a matter of law, it self-releases. you know, as I said, at one time it was much more important because if it was on your credit report, this is a big deal, you know. Now, you probably would like to have the satisfaction, but once the lien self-releases, all right, you're home free. You know, you don't have to, you beat the government. You beat us, all right? Because, we're paying for you, all right? But it self-releases. Now, the other thing that it says on there, as stated on the face of the lien itself operates as a certificate of release. But column E also gives the date, which is 30 days after the collection statute expired, or at least was designed. So when the lien, when it's issued, it says you got 10 years, and it says you can refile this lien within 30 days afterwards. What's that all about? I thought the 10-year period expired, right? Well, what that means is, remember I told you, you're in priority, right? Let's assume that you did an extension of the statute the statute was told, and there is more time on there, all right? The lien is not going to self-release, actually, but unless the service, within 30 days from that experience, puts another lien in, what do they do? What do they lose? They lose their place in line. Does that make sense? If you don't refile the lien, only for cause, I mean, you don't have, you know, the ability just to do it, you lose your place in line. So that's what that 30 days means, all right? And just one more quick thing that I'll mention. If the lien has a big number on the end, all right, the government does have the option of going to the United States District Court, and what the phrase is, they reduce the lien to judgment. And that means that they go to court, they say that this taxpayer owes us $450,000. The CSED is report. He hasn't cooperated, blah, blah, blah. And what the judge may do, no guarantee, the judge may issue now a judgment against the taxpayer. And what does that in fact do? Put another 10 years on the collection statute. They don't do that normally because most of the numbers are big, but guaranteed, if you got a big, big number, those taxpayers have to worry about it. Okay. I'm sorry?
Don't judgments not go away?
They'll be enforced for 10 years, all right?
Okay.
Right. In New York, I think this 20 years. Listen, I'm going to have to run, so if you have any questions, send me an email because I'm not going to be here, all right? Hope everybody learned something today. And hopefully, same time, same place next year, all right?